New trouble for a fire lieutenant and his wife accused of abusing a foster child. There are new charges and more allegations involving their own children. But one of their attorneys says the facts are on the parents' side.
A lock on the outside of a bedroom door, installed by a man whose entire job was rescuing people trapped behind doors just like that one. I'm going to walk you through this case exactly as investigators laid it out, because the details, if verified, will make you look twice at every perfect family photo you scroll past today. I'm Junaid, and this is Crime and Consequences. Joel and Jennifer Kohnert didn't look like a cautionary tale. They looked like the family you'd want living next door. Joel was a fire lieutenant with Broward Sheriff's Fire Rescue, the kind of job that comes with trust built in. Jennifer stayed home with their 5 biological children. And for over a decade, they were also raising a foster child, a girl who came into their care as a baby and grew up believing this was her family too.
From the outside looking in, Joel and Jennifer Kohnert look like the perfect parents in a large family. Joel was a fire lieutenant at the Broward Sheriff's Fire Rescue. Jennifer was a stay-at-home mom. The couple had 5 biological children, and they were also fostering a child, a girl, from the time she was a baby until she was 12 years old. On Facebook, the Kohnerts looked picture perfect, but the state attorney in Broward County says there was something awful going on behind the photos and behind closed doors.
On Facebook, prosecutors say it looked picture perfect. But according to a probable cause affidavit, something else was allegedly happening behind that front door, and it took a school enrollment, of all things, to bring it into the light.
The claim? The 12-year-old girl the Kohnerts had fostered since she was a baby was being singled out in the home and mistreated. The girl, according to the prosecutor, was being tortured. A detective wrote in a probable cause affidavit,
Here's where it starts. In February 2026, a Department of Children and Families investigator responded to a call at a school. The allegation the girl, now 12, was reportedly being locked in her bedroom at night. The reason given, according to the intake, was that she wandered the house and took items belonging to other family members. But it's what allegedly came next that turned a behavioral complaint into a criminal investigation. If the intake report is accurate, the girl had no access to a bathroom during these lock-ins. She reportedly urinated on the floor and was then required to clean it up the following morning. The intake also noted she was allegedly assigned Bible verses as punishment.
On February 11th, 2026, a Department of Children and Families investigator responded to the resource officer regarding allegations that blank was locked in her bedroom at night due to claims that she wandered the house and took items from the family members. The intake further indicated that during this period, the child did not have access to a bathroom, resulting in her urinating on the floor and being forced to clean it the following morning. The intake also noted that the child was required to write Bible verses as a form of punishment. So this is just the beginning of what the state attorney says was torture.
Now, hold that detail for a moment, because it gets worse before this story is through, and I want you to notice something as we go. Every phase of this case builds on the one before it. Nothing here appears to have happened once. According to investigators, it happened for years. Here's the part I keep coming back to. This girl was homeschooled for most of her life in that house. It was only after she enrolled in public school, after she was finally in a room full of adults outside her own family, that she reportedly told someone what had allegedly been happening. Ask yourself what that means. If this account holds up, an entire structure of isolation had to break down before anyone outside that house could hear her. Investigators interviewed the girl twice over 2 days. According to the affidavit, she disclosed that for approximately 2 to 3 years, she was allegedly locked in her bedroom overnight, and at times during the day. She reportedly said that while confined, she would urinate, and at times defecate, on herself due to a lack of bathroom access. In the mornings, she was allegedly required to bathe outside in the backyard, in a bathing suit, regardless of the weather.
Investigators with Children's Services interviewed the girl twice over the span of 2 days. They said things the girl told them raised serious concerns. The investigator wrote, during these interviews, The child disclosed that for approximately 2 to 3 years, she had been locked in her bedroom overnight and at times during the day. She stated that while confined overnight, she urinates on herself and at times defecates on herself due to lack of access to a bathroom. The child reported that in the morning she is required to bathe outside in the backyard while wearing a bathing suit despite inadequate weather conditions. Investigators said they also spoke with the biological children of the Kohnerts.
If verified, that's not a punishment. That's a system. And here's the detail that, for me, changes the entire shape of this case. Investigators didn't just take the girl's word for it. They spoke with the Kohnerts' 5 biological children. According to the detective's report, those children confirmed it. The locking, the self-soiling, the outdoor bathing, all of it. And they reportedly said something else. They were not subjected to that treatment. Only she was.
A detective wrote, "I interviewed all of the children residing in the home who are the biological children of Jennifer and Joel. These children confirmed that the child is locked in her room overnight, urinates and defecates on herself, and is required to bathe outside and wash her clothing. All siblings advise that they are not subjected to that type of punishment."
Sit with that for a second. If this is accurate, this wasn't one girl's account against her caregivers. It was corroborated, independently, by the very children who grew up in that same house and were, by their own account, treated differently. When you have that kind of alignment, a child's disclosure, and 5 sibling accounts pointing the same direction, you start to understand why prosecutors moved as fast as they did.
They reported that the child spent a majority of her time isolated in her room, writing proverbs, and is rarely allowed to participate in normal family activities such as eating meals and playing with siblings. So investigators say the Kohnerts' biological children told them the girl was being isolated.
Then investigators reportedly spoke to Jennifer directly. And according to the affidavit, she didn't deny it. She allegedly admitted to locking the child in her room overnight. She acknowledged the child had been urinating and defecating on herself for 2 to 3 years. She confirmed the outdoor bathing. She reportedly called the practices unusual and said the child would not thrive in her care, adding she was willing to return her to the state, despite having raised her since she was 2 months old.
And kept in her room where she's forced to write proverbs. The investigators then turned their attention to the Kohnerts. The affidavit states, Jennifer agreed to speak with me and was advised of the DCF allegations. Jennifer admitted to locking the child in her room overnight and acknowledged that the child has been urinating and defecating on herself for approximately 2 to 3 years. Jennifer confirmed that the child is required to write proverbs as punishment and that she is required to bathe and wash her clothing outside with limited access to indoor facilities. Jennifer acknowledged that these practices were unusual. Jennifer also stated that the victim would not thrive in her care.
If you noticed the shift in that sentence, from decade-long caregiver to, I'm willing to give her back, you were already ahead of where this story was headed. Joel's interview reportedly went differently, but not in his favor. According to the detective, he acknowledged that the bedroom door and window were secured in a way that restricted the child's ability to exit. And here's where his profession becomes impossible to ignore. This is a man trained, professionally, to understand exactly what happens when someone can't get out of a room in an emergency. If this detail holds up, it's not a detail that needs much interpretation.
Spoke with Joel Kohnert. The detective wrote in the affidavit during the interview, Joel acknowledged that there were safety concerns associated with the victim's bedroom door and window being secured in a manner that restricted her ability to exit. This practice is particularly concerning, and given Joel's professional background, where he would reasonably be expected to recognize the inherent safety risk is associated with restricting a child's ability to exit a room during an emergency.
That was enough for an initial charge of aggravated child abuse. But the case didn't stop there.
All of this information from the children and Joel and Jennifer formed the basis for the initial aggravated child abuse charge. But the investigation and review by prosecutors continued. And Jennifer and Joel, they were back in court this week, and they now face additional charges of child neglect and contributing to the delinquency of a minor. The delinquency of a minor charge states that a child did observe and or was encouraged to participate in the physical, mental, and or emotional abuse of a sibling.
As investigators kept digging, new charges followed: child neglect and contributing to the delinquency of a minor. That second charge is worth pausing on, because of what it alleges that the Kohnert's biological children didn't just witness this. They were allegedly encouraged to participate in it. If that holds up in court, this stops being a story about two parents and one victim. It becomes a story about an entire household allegedly organized around her mistreatment.
So the Kohnerts are now accused of encouraging their own children to take part in the abuse of their foster sibling.
Where they confirmed the information that was provided by the victim child as to the restrictions on her eating,
Going to trial today?
restrictions on her
Good luck.
movement, her being locked in her bedroom, and various other details. And that is why the additional counts for additional victims.
At their bond hearing, Jennifer's attorney pushed back hard, arguing,
I want to call the court's attention to this, because what I'm requesting is, my client has no prior record. She has two children at home, two adult children that are waiting for her. There is a pending case with the children, which is now, apparently there's an agreement that's going to be settled.
This is a dependency
Correct.
court.
Exactly.
Okay?
And I want to call attention to the court that with no prior record, my client at the magistrate hearing, the public defender at that time asked for a $15,000 bond on First County. The state of Florida asked for a $50,000 bond. The magistrate on their own required a $100,000 bond. Okay, so there's a very large bond amount in this case already.
she had no prior record, and the reason her biological children avoided contact with the foster child was reportedly due to a specific safety concern, not parental influence.
I would suggest to the court that my client could be placed on pretrial release on the other counts. I don't believe there is a necessity for an ankle monitor. They haven't been on an ankle monitor to this point, and they've been perfectly law-abiding and following all the rules as defined. And I would also just to refute something the prosecutor said, the reason that the biological children don't want to have contact with the alleged victim in this case is because they were threatened to be stabbed by them. So there's actually a valid factual reason why that is, not the inference the state is making that somehow the parents are somehow having influence on their children.
The judge acknowledged the case's severity, calling the circumstances allegedly egregious, but ultimately allowed both Joel and Jennifer to remain free on bond, with no contact allowed with any of the alleged victims, including their own children.
The circumstances of the offense are allegedly egregious. The penalty upon conviction and the weight of the evidence against the defendant in this matter weighs heavy on this court. However, the defendant is presumed innocent until proven guilty at trial. And under the circumstances, the penalty on count 1 is 30 years in prison, count 2, 15 years in prison, and individual counts of 5 years, of individual terms of 5 years in prison on counts 3 to 6.
Joel has since lost his position with Broward Sheriff's Fire Rescue. Both have pleaded not guilty.
And he lost his job. He's no longer employed with the Broward County Sheriff's. I mean, how could they keep him, right, with these allegations? And of course, he's innocent until proven guilty. These are allegations.
And I want to say this clearly, because it matters under the law. They remain presumed innocent until proven otherwise. Everything here comes from a probable cause affidavit and court proceedings. Allegations, not a verdict. But here's what stays with me. Somewhere in that house, there was a girl who had been part of that family since she was an infant. Old enough to know every hallway, every room, every face at that dinner table, but reportedly never allowed to sit at it. And it wasn't a stranger, or a mandated reporter, or a neighbor who broke this open. It was her own first day in a new school, sitting among people who had never met her family, who had no reason yet to look away. If this account is accurate, that ordinary school morning may be the reason this story exists at all.
That's how it came out. She was homeschooled and then she enrolled into public school and she told someone. If she didn't release this information to anyone, who knows how long this torture could have been going on. So, looking at the probable cause affidavit and looking at the evidence that the state has to prove beyond a reasonable doubt, this shows that
Their trial is set for August. The charges carry the possibility of decades behind bars.
in addition, some of her siblings would witness this on a daily, ongoing basis. And I have the information here, and some of the allegations for the aggravated child abuse included willful torture, malicious punishment, unlawful caging, restricted diet. She wasn't allowed to eat certain foods as her siblings, depriving access not only to the bathroom, but to other parts of the house. But what's even more egregious is that the parents would play this sound noise in her room so she would not have the access to hear what's going on in the outside. So this is beyond extreme torture, which is why she was charged with aggravated child abuse, first-degree felony, and they're looking at upwards of 30 years Florida State Prison, and you have neglect of a child, and that's a third-degree felony.
We'll be following this one closely, because the next chapter of this case, the count's still being reviewed, the biological children's futures, is very much still being written. So I'll leave you with this. When the people meant to protect a child are the ones named in the charges, who is supposed to notice first? Tell me what you think in the comments. And stay close, because what prosecutors uncover next in this case may reshape everything we think we know about it.